Hello and welcome. If you're watching this video, you probably have questions about child custody and child support in Texas, and you're in the right place. I'm Lena Wynn, a divorce lawyer, and today I'll be walking you through some important topics related to child custody and child support in Texas. Whether you're going through a divorce or you just want to understand the legal landscape better, this video will help explain things clearly. In this video, we'll discuss the following: types of conservatorship, sole versus joint, standard possession orders, calculating child support obligations, modifying custody and support orders, and how the courts determine the child's best interests. But before we get started, I just want to give a quick disclaimer. This video is meant for informational purposes only and does not constitute legal advice. Every case is unique, so please consult a qualified family law attorney for guidance specific to your situation. Now let's dive into the first topic: types of conservatorship in Texas. In Texas, when parents separate or divorce, the courts must determine how the child will be cared for. This includes decision about physical and legal custody, which are referred to as conservatorship in Texas law. There are two main types of conservatorship: sole conservatorship and joint conservatorship. Sole conservatorship means that one parent has the right to make important decisions about the child's life without consulting the other parent. This can apply to both legal and physical custody, meaning the parent with sole conservatorship can make decisions about the child's education, healthcare, and religious upbringing, and they may have the child live with them. Sole conservatorship is generally awarded when one parent has shown that the other parent is unfit or unable to take care of the child. The court looks at factors such as history of abuse, neglect, or substance abuse issues when deciding whether to award sole conservatorship. It can also be granted if one parent has demonstrated a lack of involvement in the child's life or a consistent inability to prioritize the child's well-being. However, the parent who does not have sole conservatorship is usually granted visitation rights and may still be responsible for child support. Joint conservatorship. Joint conservatorship is much more common and means that both parents share the responsibility for making decisions about their child's life. This includes important matters such as education, healthcare, and religious upbringing. However, just because parents have joint conservatorship doesn't mean that the child will live with both of them equally or have equal time with each parent. The courts generally favor joint conservatorship unless there are extenuating circumstances that suggest otherwise. Joint conservatorship doesn't necessarily mean that both parents will have 50-50 custody. In many cases, one parent may be the primary conservator, that's the parent the child primarily lives with, while the other parent has the right to make joint decisions but may have visitation rights. The key difference here is that both parents share the decision-making responsibility. It's important to note that joint conservatorship doesn't mean equal parenting time. It just means that both parents have a say in major decisions about the child's life. The time spent by each parent will be determined by a possession order. Factors the court considers. In deciding whether to award sole or joint conservatorship, the court will consider the following factors: the child's age and needs. A child's age, emotional needs, and developmental stage will influence the decision. Younger children may benefit from more stability and consistency, which could favor one parent having primary conservatorship. The parent's ability to cooperate. Joint conservatorship requires a certain level of cooperation between parents. If there is a history of high conflict or an inability to communicate effectively, sole conservatorship may be preferred. History of abuse or neglect. If there is a history of abuse, neglect, or any form of harm to the child or one of the parents, the court may award sole conservatorship to the non-abusive parent to protect the child's safety. The child's preference. In certain cases, particularly if the child is over 12 years old, the court may take the child's preference into account. The child's expressed desire may weigh in the decision, though it is not the only factor. Which is the best situation? The type of conservatorship that is best for you and your child depends on several factors, including the relationship between you and your co-parent, your child's needs, and any history of abuse or neglect. Most courts do favor joint conservatorship because it encourages both parents to remain actively involved in the child's life. However, in cases where one parent is unfit or there are concerns about the child's well-being, sole conservatorship may be granted. Standard possession orders. Once conservatorship is determined, the next issue is visitation, or the time each parent spends with the child. In Texas, this is typically outlined in what's called a standard possession order, also known as an SPO. A standard possession order is a set of guidelines established by the Texas Family Code that determines when and how the non-custodial parent will have possession of the child. While parents can agree to a different possession schedule, the SPO serves as the default. Who gets the standard possession order? The standard possession order typically applies to parents who share joint conservatorship, but it can also be used in cases where one parent has sole conservatorship and the other has visitation rights. The purpose of the SPO is to give the non-custodial parent regular access to their child while ensuring stability for the child. The standard possession order provides specific visitation guidelines for weekdays, weekends, holidays, and vacations. It is designed to balance the child's need for a stable home environment with the desire for the non-custodial parent to maintain an ongoing relationship with the child. For example, under a typical standard possession order, the non-custodial parent may have visitation on the first, third, and fifth weekends of the month, plus one evening during the week, usually a weekday evening. For weekday visits, the non-custodial parent may have the child from 6 p.m. to 8 p.m. one evening a week, typically on a Wednesday or a Thursday, but this can vary depending on the distance between the parents' homes. For weekends, the non-custodial parent has visitation on the first, third, and fifth weekends of the month, typically from Friday evening until Sunday evening. The child is usually returned to the primary conservator on Sunday evening. Holidays are split in a way that ensures both parents have the opportunity to spend time with the child on important dates. The standard possession order outlines which parent has a child on holidays like Thanksgiving, Christmas, Easter, and birthdays. This is usually alternated every year to ensure fairness. Summer and vacation time. Parents are also entitled to extended visitation during the summer. Typically, the non-custodial parent can have the child for up to 30 days during the summer, and this time is usually negotiated and agreed in advance. Can the standard possession order be modified? Yes. The standard possession order can be modified if there is a significant change in circumstances, such as a change in the parent's work schedules, relocation, or other factors affecting the child's best interest. The court will evaluate any proposed changes based on the child's best interest, so it's important to demonstrate why the modification is necessary. Calculating child support obligations. In addition to conservatorship and visitation, parents who are not living together are also responsible for child support. Child support is a financial obligation intended to ensure that the child's needs are met. How is child support calculated? The amount of child support one parent owes is typically based on their income and the number of children they are supporting. Texas uses a formula to calculate child support obligations. The primary factors in this calculation include the paying parent's net income. This is the parent's income after taxes and other deductions. The number of children. The child support amount will increase with more children. Percentage of net income. Texas follows a percentage guideline to determine the amount of child support. For one child, the non-custodial parent will typically pay 20% of their net income. For two children, it's 25% and so on. For example, if a parent has one child and their net income is $3,000 per month, the child support obligation will generally be 20% of that, which equals to $600 per month. Additional expenses. In addition to the basic child support amount, the court may also order the non-custodial parent to contribute to other child-related expenses, such as medical expenses, daycare, and extracurricular activities. These expenses are usually divided between the parents based on their income or as agreed upon in the divorce decree. What happens if a parent doesn't pay? Failure to pay child support can result in serious consequences. The parent who is not paying may face wage garnishment, tax refund interception, or even jail time. It's important to make child support payments on time to avoid these penalties. Modifying custody and support orders. As time passes, circumstances can change, and that might mean that custody and support orders need to be modified. If there has been a significant change in circumstances since the original order was made, either parent can petition the court to modify the terms of custody or child support. Reasons for modification. Some common reasons for modifying custody or child support orders include relocation. If one parent moves to a different city or state, it may impact custody arrangements or the distance the child has to travel for visitation. Changes in income. If a parent loses their job or experiences a significant increase in income, the child support amount may need to be adjusted. Changes in the child's needs. As children grow, their needs change. For example, a child may require different educational services, healthcare, or extracurricular activities, which could impact custody or support. How to modify orders. To modify custody or child support orders, the parent requesting the modification must file a motion with the court. The court will then evaluate whether the change is in the best interest of the child. Keep in mind that the process of modification can take some time and that the court's decision will be based on the specific facts and circumstances of your case. I hope this video helped clarify some of the important aspects of child support and child custody in Texas. Remember that every case is different, and if you're going through a divorce or custody battle, it's important to consult with a qualified family law attorney to ensure that your rights and your child's best interests are protected. If you found this video helpful, please like, comment, and subscribe to my channel for more legal insights and tips. And as always, if you need help navigating your own divorce or custody case, please don't hesitate to reach out. Thanks for watching, and I'll see you in the next video.